If you guys could give me your attention one more time, this is Judge Nicholas St. Peter, who's the Chief Judge of the 19th Judicial District. He's going to give you a short summary of the cases. So please help me welcome Judge St. Peter.
Good evening, and thank you very much. On behalf of the Kansas Supreme Court and the Office of Judicial Administration, the judges and staff of the 19th Judicial District, I'm pleased to welcome you to this evening's special night session of the Kansas Supreme Court. This is the 9th time that the court has held a special session outside of their own courtroom, and the 6th time that they've done it in the evening. And of course, this is the first time they've been here in their 156-year history. And it's, I think, nice that they're here this year, since here in Cowley County we're celebrating our sesquicentennial 150th anniversary. There are 2 cases on the docket for this evening. There's a brief description of the cases within the handout that you received, but I'll go over some additional facts with you. The program that you received gives you some information about your court. I would invite you to take a look at the biographical descriptions of the justices when you have time and get to know your judicial branch of government. This court, the Kansas Supreme Court, sets as what's called a hot bench, which means that the justices have thoroughly reviewed and researched all of the legal issues that will be argued and presented tonight, and therefore they will be prepared to ask the attorneys questions specific to the arguments that they're making. The first case that's on the docket for hearing tonight is a medical malpractice action that originated in the District Court of Sedgwick County, Kansas. In that case, the plaintiff, Ms. Stacy Russell, filed a lawsuit against her family care physician, Dr. Gehring, and against a radiologist, Dr. May, and her OBGYN physician, Dr. Kendall. In the lawsuit, Ms. Russell sought compensation from the 3 doctors based upon claims that they were each professionally negligent when they delayed diagnosing her breast cancer, reducing her chance for a better recovery and long-term survival. At the trial in this matter, the district court judge dismissed Dr. Gehring from the case at the end of Ms. Russell's evidence. The matter was then considered by the jury with respect to the 2 remaining doctors. The jury found that the 2 remaining doctors were not at fault. The plaintiff appealed the trial judge's rulings to the Kansas Court of Appeals. That court found that the trial court was correct in dismissing Dr. Gehring from the action because her negligence, if it did exist, did not cause or contribute to Ms. Russell's chance for a better recovery. They also found that if the trial judge was wrong in dismissing Dr. Gehring, that decision was harmless because the jury found that the other doctors providing subsequent care to Ms. Russell, were not at fault. Ms. Russell has asked the Kansas Supreme Court to review the decision of the Court of Appeals, arguing that the Court of Appeals used the wrong legal standard in dismissing Dr. Gehring from the case, relied on incorrect factual findings to support their decision, and used the wrong legal standard when it determined that a jury finding that the other doctors were not at fault meant that Dr. Gehring would not have been found at fault by the jury. The Kansas Supreme Court has granted review on these issues. The second case for argument this evening is a case that originated in the District Court of Harvey County. In this case, Mr. Marcus Gray, an African-American gentleman, was operating a motor vehicle that was stopped by a law enforcement officer at about 2 a.m. when he failed to use a turn signal in making a lane change. Prior to stopping Mr. Gray, the officer observed that Mr. Gray was traveling in a vehicle registered to a female from Saline County. He also observed that the vehicle made a quick exit off the highway and stopped at a nearby gas station, pulling up to the gas pump, which the officer incorrectly thought was on the wrong side of the vehicle to pump fuel. The officer observed Mr. Gray enter the store and then return to the vehicle, looking around before he entered the vehicle. He noted that Mr. Gray did not obtain any fuel for the vehicle. The officer deemed all of this conduct suspicious in nature. After stopping Mr. Gray's vehicle, he noted a moderate odor of marijuana, a slight odor of an alcoholic beverage emitting from inside of the vehicle. Mr. Gray could not produce a driver's license and initially gave the officer an incorrect name and social security number. After a pat-down search, Mr. Gray attempted to run but was restrained by the officers. Mr. Gray accused the officer of engaging in racial profiling. Later, while being processed, Mr. Gray was found to be in possession of marijuana and cocaine. At the district court, Mr. Gray challenged the stop of the vehicle as well as his arrest and search. He argued that the stop of his vehicle violated a Kansas law that prohibits police officers from engaging in racial profiling. The trial court found that there was sufficient reasonable suspicion to stop Mr. Gray and that the officer's action were not the result of racial profiling. Mr. Gray appealed to the Kansas Court of Appeals. The Court of Appeals found that a violation of the statute that prohibits racial profiling can be the basis for the suppression of evidence. They found, however, that whether a law enforcement officer unlawfully used racial or other bias-based policing is a question of fact to be determined by the trial court. In this case, they found that there were sufficient facts in the record to support the trial judge's conclusion that racial bias was not the basis of the stop of Mr. Gray. Mr. Gray then asked the Kansas Supreme Court to review the case. He argues that to give effect to the statute that prohibits racial profiling, the state should have to prove that race was not a contributing factor to an investigatory stop. Additionally, Mr. Gray argues that because he was not charged with felony possession of marijuana and the district court did not have jurisdiction to sentence him for a felony offense. The court has agreed to hear these cases on these issues. That's a brief overview of this evening's cases. If you are piqued by this evening's arguments, all of the Supreme Court's arguments are online in real time at kscourts.org. Additionally, they're all archived, so if you want to go back later and rewatch this again, if you have some questions about it, it'll be on their website. Thank you very much.
All rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to this court. Now, sitting.
Thank you. Please be seated. Good evening. And welcome to this special session of the Supreme Court of Kansas. We're very pleased to be holding this session in the Richardson Performing Arts Center at Southwestern College. Beginning in 2011, our court has made an effort to be more accessible to the people that we serve. This helps Kansans learn more about our court and in turn more about the judicial branch of government. For example, tonight we will not do a public opinion survey or ask you to tell us how you think we should vote on these two cases. But as you will see, we will ask the attorneys questions to help us perform our duty, which is to interpret the law and make the decision that the law requires and not based on our personal beliefs or political interests or special interests. This is the Supreme Court's first visit to Winfield in the court's 156-year history. And this is only the 6th time in which we have held court or arguments in the evening. We have held special sessions in Salina, Greensburg, Overland Park, Wichita, Pittsburgh, Kansas City, Hayes, Garden City, Topeka, Hiawatha, and Hutchinson. To paraphrase an old Beach Boys song, we get around. I'd like to introduce the members of the court that you will be listening to this evening, and I'm going to do it by seniority. I am a native of Salina. To my right is Justice Marla Lukert. Her hometown is Goodland, almost on the far western border. On my left is Justice Carol Beyer. Her hometown is Kansas City, Kansas, about 400 miles to the east of Goodland. To Justice Lukert's right is Justice Eric Rosen. His hometown is Topeka. Further left, this is Justice Lee Johnson. He's from a place called Caldwell, Kansas, which everybody here, I'm sure, knows. It's in the adjoining county. To the far right is Justice Dan Biles. His hometown is El Dorado, not too far from here. And to the far left is Justice Caleb Stiegel. His hometown is Lawrence. So you can see we are all native Kansans and we come from all parts of the state. An activity like this takes a tremendous amount of planning, and I want to take just a minute to thank those people who worked very hard to make this a successful event. Thank you, of course, first of all, to Southwestern College President Dr. Brad Andrews and all of your staff who assisted with these great arrangements. You've gone out of your way to work with our staff to help plan this event, and we appreciate your hard work. So we extend a warm welcome to Dr. Andrews, the College Board of Trustees, and the educators, staff, and students who are in attendance this evening. This session is being video streamed, so be careful, you may be caught on camera. And we appreciate the expertise of the Southwestern College staff in making these arrangements. I also want to thank all the law enforcement and security who are in attendance this evening. A special thank you goes out to Chief of Police Danny Parker of the Winfield Police Department, Sheriff David Folletti of the Cowley County Sheriff's Department, Captain David Martin of the Kansas Highway Patrol, and Chief of Police Daniel C. Ward of the Arkansas City Police Department. We thank you all for helping provide security this evening. I also want to welcome and thank Chief Judge Nicholas St. Peter and the other judges and court staff of the 19th Judicial District who are in attendance. We thank you for your assistance with this event. Also, welcome to the members of the Cowley County Bar Association and the Sumner County Bar Association, and we thank them for their assistance. We enjoyed having our lunch with you today. I also want to thank our honorary bailiff. This is Marilyn Leith, who called things to order this evening. She began her employment with the judicial branch as a deputy clerk in, are you ready for this? June of 1986. And she was appointed chief clerk in June of 2008. During her years of service, she's been a very hard worker and a leader in this district, and she is the person that we all think of when we hear the term a dedicated public servant. So Marilyn, congratulations on your many years of service, and thank you for honoring us by your serving as our bailiff this evening. The justices did not just come to town to hear arguments tonight. One of the things that was done this afternoon was the justices teamed up with your local judges, and they visited area schools where they enjoyed presenting to the students, taking lots of questions, and visiting with students and teachers. I would like to briefly indicate where these sessions occurred. Here at Southwestern College, Justice Rosen and District Judge R. Scott McQuinn from Wellington, who is in the nearby 30th Judicial District. Cowley College, Justice Biles and District Judge Bill Mott, also from Wellington. Udall High School, Justice Johnson and retired Judge James Pringle. Winfield High School, Justice Lukert and District Judge LaDonna Lanning. Our Kansas City High School, Justice Beyer and Chief Judge Nick St. Peter. Dexter High School, Justice Stiegel and District Judge Christopher Smith. I'm told that students from Burden's Central Junior and Senior High School joined the students at Dexter High School, and I've been informed that approximately 600 students attended these sessions this afternoon. We thank all of you for coming this evening with your help. This should be a great session as we make history. As I said, the first time our court has come here in 156 years, and this is happening during Cowley County's 150th year as a Kansas county. We invite you to attend a reception in the outside hall at the conclusion of the proceedings this evening. We would welcome the opportunity to shake your hand and visit with you. If you have your camera and want some photos taken, that would be great. In the past, some people have asked for their programs to be autographed, and I'll tell you that Justice Johnson said that since he is from Sumner County, he will only charge you $50 for a photograph. I'm now going to call upon Mr. Doug Shima, who is the clerk of the Supreme Court of Kansas, to do the honor of calling the docket this evening. Mr. Shima.
May it please the court. Thank you, Your Honor. May it please the court. The docket for Thursday, March 30th, 2017 consists of two cases. First case, appeal number 111671, Stacy Russell versus Lisa May, MD, et al., Sedgwick County, briefs both sides. Attorneys enter their appearance for the first case.
Your Honors, I'm Craig Schultz, have the privilege of representing Stacy Russell, and we are ready for argument.
Lisa McPherson, I represent Dr. Lisa May, and I'm ready for argument.
Good evening, I'm Mark Maloney. I represent Dr. Victoria Kendall, and we are present and ready for argument.
Good evening, Gregory Young. I represent Dr. Gehring. I'm present and ready to argue. Thank you.
Second case, appeal number 112035, State of Kansas versus Marcus Gray, Harvey County, briefs both sides. Attorneys enter their appearance.
Your Honor, my name is Randall Hodgkinson. I'm here tonight on behalf of Marcus Gray, and I'm ready for argument.
Good evening. My name is Jason R. Lane. I represent the state of Kansas, and I'm the Chief Deputy Harvey County Attorney. And I'm ready for argument.
Your Honor, that concludes the docket for March 30th, 2017.
Thank you, Mr. Shima. I will now call the first case on this evening's special session. That is case number 111671, Stacy Russell v. Lisa May, MD, et al. Counsel, just before you begin, I wanted to announce that we will not be taking a break in between the two arguments this evening. So if you feel a need to take a recess or a break, please do so, but do it very quietly so as not to disrupt counsel when they're making their arguments. Thank you.
Your Honors, again, I'm Craig Schultz. If I may, I'd like to reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you. In 2008, Stacy Russell felt a lump on her breast. During a self-exam, she went to her doctor, Tana Gehring, and was evaluated. She sent her to Lisa May, who's a physician, to do a mammogram. She ultimately performed also an ultrasound and sent her away with a report that things were okay, that she didn't have anything to worry about, that she could come back in 5 years. What she had found was, she didn't actually tell him, but in her report ultimately, she said she'd found a fatty lobule. She told her to come back if something changed. Stacy continued her breast exams on a regular basis, frankly, way more than regular for a long time. And ultimately, about 2 years later, in August of 2010, she felt the lump had increased in size. It was a rather quick change. She immediately went back to Dr. Gehring with a telephone call. They sent her for a biopsy. The biopsy showed that she had malignant grade 3 invasive ductal carcinoma. Stacy underwent significant treatment, which is not really the big issue in this particular case. I will simply tell you that the evidence was clear on the plaintiff's side that one of our experts, Dr. Edney in particular, said that the lump in 2008, if biopsied, would have shown the existence of cancer. If caught in 2008 following a biopsy, the treatment would have been much less significant than it was, and her odds of survival long-term would have been much, much better. So the question became, and certainly the defendants contested that to some extent, but the question became whether or not this should have been biopsied. Dr. Gehring said, I sent her to see Dr. May. Dr. May said, I did a test. Everything looked okay. Dr. Kendall comes into this because she was the well woman exam 6 months later. Stacy also explained to her about the lump on the breast and told her that she'd been told by Dr. May that everything was fine to come back in 5 years. She actually was seen twice. Dr. Kendall did not recommend a biopsy.
Mr. Schultz?
Yes.
I have a question just about the relationship among the doctors. So her OBGYN, that was just routine care, annual exams, not set up in any way through or by her primary care physician. Is that right?
Absolutely correct.
Okay, thank you.
Just normal care. And so we had Dr. Edney, who was our expert, who basically testified as to the extent that when you come in, and Stacy was a young woman with 2 young children, and Stacy, when you come in and you've got a lump, you deserve to have that biopsied if it doesn't resolve or if there's not clear evidence in some fashion.
Counsel,
that
here's
it's not.
the thing I didn't understand about that part of Dr. Etsy's expert opinion was, as I read it, he's saying that one of 2 things should have happened after the radiology report came back. One is to have a biopsy, but the other was, if you're not going to do the biopsy, have your client come back in 3 months for an examination. So if that's right, then the fact that Dr. Kendall did an exam in February of 2009 and it came out negative, I don't understand how Dr. Gehring caused any damage, because if it's within the standard of care to have an examination within 3 months, and there was another exam, even though it was by a different doctor, and it came out negative, why are we complaining?
Well, you're falling into the same trap the trial judge did and the appellate court did, the Court of Appeals. The testimony was that when she first went to see Dr. Gehring had 2 choices. One was to do a biopsy immediately, and the other one was to send her to a mammogram, wait 3 months, have her come back in 3 months or thereabouts. He said a finite period between 3 and 6 months, because the tumor would not have upgraded by that, upstaged by that time. So come back in that period of time, and if the lump is still there, you must biopsy it. That was the testimony. And it didn't matter what the mammogram showed, because with a young woman with dense breasts, the mammogram has about a 30% or greater failure rate at that age.
But all that aside, you're saying that Dr. Kendall's exam actually triggers it, because he did an exam, and even though he said it was negative, there was still a lump there. And so if your expert is saying that because there still would have been a lump after 3 months, it breached the standard of care. Is that what is that the point?
There's 2 reasons. First, he says if the lump is still there, it hasn't gone away. And sometimes lumps in young women do go away. If it hasn't gone away, then she's entitled to have it biopsied, and that is the standard of care. Dr. Gehring is required to biopsy it at that point in time. Why doesn't that apply to Dr. Kendall, who, by the way, is female? Dr. Kendall also has that same knowledge. The difference potentially is that Dr. Kendall has the intervening miscommunication that all is fine from the mammogram. In fact, the mammogram that was reported from Dr. May said this woman has dense breasts. It's not certain that this is accurate. I'm paraphrasing here, but we cannot rule out cancer. And so Kendall has got some information that's actually incorrect, not through the fault of my client, but because Dr. May didn't give her the reports.
Counselor,
the reports went back to Dr. Gehring. My client was never given the reports.
let's talk a little bit about the information Dr. Kendall had when she did the exam some few months later. Did she have anything to indicate the size of the lump that Dr. Gehring had discovered or examined, or the firmness and other things that you rely on, that this was firm and so more likely cancerous than a fatty lobule? Was any of that information in Dr. Kendall's possession for her to compare what the lump looked like during her exam versus what Dr. Gehring had?
I'm scared to say 100%, but my recollection is that no, she did not have anything. She did her own exam, of course, and she said it was a palpable lump as well. That's the other issue, Justice Piles, I think that I wanted to get to with you, is that not only is the lump itself a problem, but the lump is described by Dr. May as a fatty lobule. That's a squishy thing, and Dr. Kendall and Dr. Gehring are palpating this and saying it's a firm lump. And so Dr. Edney, my expert, says when you have that inconsistency, you've got one test saying it's a fatty lobule, the other one, it's firm. You can feel that it's firm. That's an inconsistency that requires biopsy. And if you did a biopsy, it would have shown cancer. That's the essence of this, of the expert witnesses.
See, I don't understand why that doesn't cut against your position. If Dr. Kendall had the same information that Dr. Gehring had, that is, that it was palpable, it was inconsistent with the fatty lobule that was in the sonogram and mammogram, then why wouldn't that trigger the same situation as it would have with Dr. Gehring? And if so, why wouldn't that be an intervening circumstance, or at least render the first one harmless?
Well, you've got a lapse of time that's going on, so you've got comparative negligence. I mean, we're in a comparative negligence state, so you've got to compare it. We added Dr. Kendall for that very reason, because Dr. Edney, remarkably, basically had the same testimony as to Dr. Kendall and as to Dr. Gehring. And then the judge only lets Gehring out.
What did the jury do about Dr. Kendall?
The jury found that she was not negligent.
And what, if anything, do we make of that finding by the jury as it applies possibly to your argument for your counsel?
You make of it this, Your Honor, and this is in my brief as well. When after Dr. Gehring, after about a week, the judge lets her go home. And now I'm there, I've made allegations against Dr. Gehring, and now I'm left knowing that the jury is only going to have the opportunity to find against Dr. May and Dr. Kendall. They can't, on the line, put anything on Dr. Gehring. Dr. Smith, who is one of the experts for Dr. May, gets up there, and during cross-examination, I'm asking him, doesn't the radiologist, Dr. May in this case, doesn't she have a duty to tell her patient about the results of the study? And he blurts out, volunteers, no, that falls on Dr. Gehring. And that's beyond his disclosure. They'd never made that allegation before. He did it again. We said, Judge, strike that. This is not right. And he goes, I'm not sure what the question was. I don't think that's what he was really getting into. But I've quoted the question. You can see he's clearly saying the standard of care dumps it back on Dr. Gehring. So sure, what's the jury going to think? The jury probably thinks that that Dr. Gehring went home because she paid my client a lot of money. She probably settled, and now this lawyer's up there trying to go after the remaining 2 defendants. That's not fair.
But wasn't the jury instructed that they could not consider anything other than the negligence of the 2 remaining defendants? And are we supposed to assume that they follow the instructions? Isn't that pretty black letter law?
I'm not sure I understand your question.
Well, the jury was limited. The jury was told by the judge that they were to consider only the potential negligence of the 2 remaining defendants, and that's the limited scope of their consideration. You're asking us, I guess, to speculate, but doesn't the law say we don't do that? And that we presume they follow the instructions?
I don't think I'm asking you to speculate. I'm asking you to say that it wasn't right for Dr. Smith's expert to voluntarily blame it off on now the absent doctor. And we can pretend that this is speculation, and with no offense to the question, because I appreciate the question. But I mean, I've tried a lot of cases, and juries just wonder what went on. And when they're now told that this expert says, oh, it was her fault, and they can't blame it on her because who knows what they thought. And the judge says to me, well, Craig, you can cross-examine him about this. That's the Hobson's choice. I've got to stand up and say, oh, it really was her fault. That's not a real choice. So it put me in a predicament where I now can't win against these 2 doctors either, because they've successfully blamed it, or at least that's my argument, that they've potentially blamed it off on the other doctor. I'm entitled for my client to have a trial with 3 doctors all the way through. The evidence is clear. And the judge threw out one of the doctors for reasons that are just completely beyond the evidence or any real justification.
Counsel, I see you're out of time. Would you like 30 seconds to wrap up, and then we'll see you on rebuttal, or do you think you've made your points?
I'm fine. Justice Luker, looked like maybe you were questioning something.
Well, just as your last statement, I've heard you make an argument about Dr. Gehring and about Dr. Kendall, about Dr. May in terms of what her expert did. How do you get to, what's your justification for asking for a retrial as to all defendants?
Well, I think my client is deserving of a full trial just like they're deserving of a full trial. It's not, I guess one could say it's not Dr. May's fault that the judge in error let out Dr. Gehring, and maybe it's not Dr. Kendall's fault that he let her out. But it's not my client's fault either, and she hasn't had her full day in court. That's as good as I can come. We spent a lot of time. It took 2 or 3 years to get this case ready. We go to trial, and then to have this happen is not right. I don't know if that answers.
Other than the testimony that you've described from Dr. Smith, I think you said was the expert for the defendant, is there another piece of evidence you can direct us to, or something concrete other than a kind of general fairness argument on why the verdicts on the 2 other doctors should not stand?
Well, I suppose from a purely legal point of view, one would say that the judge, I can't say that he favored in the instructions. I don't know if I'm just making something up here. I'm trying to be blunt about it. Dr. Edney testified clearly that Dr. Gehring was negligent. We put in exhibits. We put in the Lang 2008 learned treatise. It was admitted into evidence.
I understand all that. Maybe we're not communicating. I'm trying to focus on the relief you seek as to the 2 remaining defendants. You've asked for a new trial against them as well.
Right.
I just am not quite grasping why you are entitled to that relief.
Well, I guess at the end of the day, it is a fairness argument.
Okay.
If you grant me a new trial, grant Stacey Russell a new trial against Dr. Gehring only, okay, we're going to be in front of a jury. I'm going to be making my argument against Dr. Gehring alone, and Dr. Gehring there'll be potentially that they'll bring in witnesses and say, it wasn't my fault, it was Dr. May's fault. When they're all together in the same trial, they won't point the finger at each other. Okay, we all know that. You can look at the evidence, you can look at the pretrial, and you can see that they say, if one gets out, then we get to point the finger. Otherwise, they won't. They'll all stay together. So now you're going to put me in a position, put Stacey Russell in a position where she's got 1 doctor, leave the other 2 doctors out, And Dr. Gehring's lawyer is going to come in and say, let's point the finger at Dr. May because it was really her fault, or Dr. Kendall for not picking it up. That's not fair. I don't have a better argument than that.
All right, thank you, counsel.
Thank you.
May it please the court, Greg Young on behalf of Dr. Gehring, who was Ms. Russell's primary care physician, who was dismissed after the close of the plaintiff's case in chief, after the trial court heard all of the evidence, including the evidence by Dr. Edney, and he focused on the claims that were clearly set forth in the pretrial conference order, which I think is a key issue in this case. And we've cited those in our briefs, but the only claim against Dr. Gehring and Dr. Kendall were exactly the same, and they were failure to recommend biopsy or additional timely evaluation, even in the face of reported normal imaging finding.
Did they have different sets of information before them to make their decisions?
Yes and no. The plaintiff's position through Dr. Edney and his testimony was that mammograms and ultrasounds are good pieces of information, but if you have a persistent mass and it doesn't go away and you have negative imaging, you must biopsy it. And so I believe, I forgot if it was Justice Biles that brought it up, but the question was to Mr. Schultz about how do you distinguish if you have a persistent mass to both of them, whether they've seen the report or not. Your position was to the jury, you must biopsy it if the mass remains present. And Dr. Kendall had that information.
So there is a difference right there in their information, because one doctor is seeing her on X date and one doctor is seeing her on X plus Y date, right?
Yes,
so that's different information.
It is different. In the briefs, I asked Dr. Edney in trial, I got an admission from him. I said, the only difference in your opinion, let me start over again. You agree that Dr. Kendall was actually in a better position, had more information than Dr. Gehring did because time had passed and the lump was still present, correct? And he said, yes, that's right. Dr. Kendall actually had more information to be able to make this decision. The reason that's important is the jury heard all this and the jury rejected that claim as not being persuasive to them in their verdict that they rendered.
So just I want to make sure I'm tracking here. It sounds like what you're saying is that the information in Dr. Gehring's possession was different from the information in Dr. Kendall's possession, but it was a subset.
It was not?
It was a subset of the information available later. Is there any other difference?
I guess what I would say is the substantive information that needed to be known under the standard of care was known by both of them. The only thing that Dr. Gehring would know that Dr. Kendall would not know was that I believe it was in the ultrasound report, Dr. May described it as a fatty lobule.
Right. And that's pretty critical, I think, isn't it, counsel? That Dr. Gehring was in possession of information that what she had detected personally was different from the description that Dr. May arrived at, correct?
That was not a claim in the case that was a major difference as it applied to why Dr. Gehring was negligent. It was a claim that was put into evidence against all three doctors. They were talking about how Dr. May should have never described it as a fatty lobule because it was firm, that Dr. Kendall should have biopsied it because it was firm, it wasn't a fatty lobule, that type of thing. The other thing I would point out is that is a very subjective description. Reading a radiology report that says...
It's subjective, but regardless, Dr. Gehring was aware that what she had detected personally was different from what was described in the radiology report.
Potentially different.
And that information was unique to Dr. Gehring.
Yes.
And given that, how can we know that the jury result would be the same if Dr. Gehring had been left in the case?
Because the claim and the evidence through Dr. Edney was that the fatty lobule was a red herring that the defendants can't use as a defense, is basically what he was saying, because it doesn't exonerate them to say, well, she identified it and described it as benign because it's a fatty lobule, because it's firm. The firmness was known by every physician. And the firmness is what the key was from the plaintiff's perspective, that it was firm and persistent. Those are the two things. And if you read the literature and you read the testimony, what they have said is the two things are that it persists and it's firm. And that is what mandates a biopsy according to Dr. Edney, not according to others. And the jury viewed that and determined that a firm persistent mass did not require a biopsy under those specific circumstances.
Why didn't Dr. Edney's testimony, along the lines that we're talking about, sufficient to keep it in front of the jury? I mean, he testified we had two inconsistent findings, and Dr. Gehring should have been aware of that when she got Dr. May's results, and that information is sufficient enough to keep this in front of a jury. I mean, that's what we're talking about. Aren't these kind of questions that the jury should resolve and not us up here?
I will tell the court that this issue has become a much more contested, important, pointed out issue to the Supreme Court than it was to the trial court. This was not an issue argued at the trial court that Dr. Gehring had some different information that Dr. Kendall did not have. At the trial level, the presentation was that they both are at fault, that Dr. Edney has said they're both at fault, they both knew about the persistent lump, they both knew about that it was firm, and they both had to get a biopsy. This distinction has been drawn during the appeal. First, gently with the Court of Appeals, and now violently with the Supreme Court, as if you read the rhetoric in the brief, describing the Court of Appeals opinion as being clueless and baseless and a cover-up and things like that. That has developed based on a change in position by the plaintiff, because the plaintiff has to distinguish Dr. Gehring from Dr. Kendall to make this argument. But it wasn't presented that way when we were at the lower levels. It has become much more prominent as the different opinions have come down from the trial judge and the Court of Appeals to be able to try to establish that there is a significant marked difference between the two of them when there is not. And in our brief, we try to emphasize that.
To put your argument in legal terms then, can I break it down just to see where it is we fall off? You agree that Dr. Gehring had a duty to Ms. Resel?
I think that her duty ended after the results were done and that she continued with her care elsewhere. I think that's a very close call. I think it's very factually specific to that case. I think more importantly, I think there is no causation to connect the plaintiff's injury, which is a delayed diagnosis and a substantial reduction in her chance of recovery. The evidence at trial was that the lump had not changed at all in size up through Dr. Kendall's visits, and Dr. Edney agreed that he had no evidence that he could offer that there was any change in her chance of recovery by the time Dr. Kendall saw the patient. So I think the causation and then the harmless error argument are the two strongest arguments, and that is exactly what the Court of Appeals focused on in their opinion.
Doesn't the causation argument, didn't Dr. Edney say enough, though, to get it in front of the jury on causation?
I do not think he did. The court looked at it legally and applied it under the Nunez case, and I think I'm trying to remember the other case, where it said that magic words can be said, but you have to apply the expert's opinions to the actual facts of the case, and it has to make factual sense. We're not going to let an expert just create something that legally doesn't meet the standard for causation. And that's basically what Judge Vining ruled. And I think when you look back at it, his ruling makes perfect sense in the ultimate outcome of the case. The jury has looked at the same information applying to both Dr. Kendall and Dr. Gehring. The plaintiff also claimed that Dr. May had the obligation to get a biopsy at the time she saw the patient. The jury rejected that theory as well. And so I think there's a consistent finding throughout this. And then finally, I think the harmless error argument from the Court of Appeals cited is a strong argument. And there is no cases stating that in Kansas, but there are in other jurisdictions, and I think it's a logical premise that should be pursued in cases like this.
Just so I'm clear, counsel, you're basically arguing that there is symmetry between Dr. Kendall and Dr. Gehring.
Yes,
And both counsel for both those doctors filed motions for judgment as a matter of law. Is that right?
I don't recall if Mr. Maloney did, but he may have.
Well, if you don't know the answer to that question, I cannot ask you my follow-up.
I'm sure he probably made I don't know how passionate it was or what the basis of it was, but we usually always make one.
But Dr. Gehring's motion was successful. Dr. Kendall's motion was not, even though they were in symmetry.
Based on the timing of the interactions and the lack of injury from the initial interventions.
And so is it your position that the trial judge made a mistake or an error in not granting your client's motion for a judgment as a matter of law?
You mean in not granting Dr. Kendall's?
Yes, I'm sorry.
No, Dr. Kendall saw the patient 2 additional times where the plaintiff's position was that in 2009 and 2010, that if either time of those she would have biopsied a persistent mass that now had been there for a year and a half unchanged, that she still would have had the same recovery, basically. And that was their claim against Dr. Kendall. And so there's a year and a half of time that Dr. Kendall continued to evaluate and choose not to do the biopsy after the imaging.
So is your argument that subsequent treatment breaks the causal link?
It can in certain circumstances. I think it's not, in lots of cases, it would not. It would depend on the circumstances of that case and the role of the different providers. In this case, Ms. Russell, she only would go see Dr. Gehring for a very specific problem, a cold, flu, rash. She came in to get the mammogram and the ultrasound. She would go to Dr. Kendall every year for her well woman exam, which would include her breast exam and her evaluation of her condition. The other issue that I might point out, I should clarify myself, Chief Justice, they were not in the exact same position, because the plaintiff's claim was that she told Dr. Kendall in 2009 that she was very worried about this persistent lump in her breast, and that she was very, very concerned, and what could they do about it? And Dr. Kendall said, she said you don't need a biopsy. Now, Dr. Kendall's testimony is, I gave her the name of 2 surgeons that could do the biopsy and said, if you're worried about it, you should go contact these doctors. So in fairness to my client, I need to point out that they had similar information on a clinical standing, but the factual information between the patient interaction was much different.
That's what I was trying to get to before.
Yeah.
It seems like your argument for harmlessness rises and falls on that symmetry that my colleague referred to.
Yeah.
And you don't have it. As a matter of fact, you don't have symmetry. You have greater information in certain respects in the possession of your client, and you have greater information in certain respects in Dr. Kendall's possession. And doesn't your whole harmlessness argument rise and fall on that?
The only difference is that the ultrasound report said fatty lobule, and I'll just go back to the point that was never an issue where there was some position taken in the case that put Dr. Gehring in some type of different position that gave her some type of information that was important to the diagnosis.
Regardless of the legal arguments made by counsel, wasn't that in fact the opinion of Dr. Edney? That it did put your client in a different position?
No. I quote from Dr. Edney the position that the only difference that Dr. Kendall knew everything that Dr. Gehring knew, in his opinion, that needed to be known, plus she had the passage of time and a persistent mass.
Do you have a record citation for that?
It's in our brief. I believe it's volume 3, page 53 to 60, and volume 4, page 35 to 40, and 90 to 92, and it's on page 8. I believe I've copied this out of our supplemental brief to the Supreme Court after you agreed to hear the case.
Any further questions? Justice Johnson.
I'm hearing you say that Dr. Edney essentially said both your client and Dr. Kendall were negligent. Were negligent.
Yes, he used those words.
And if they're both negligent, why isn't it a jury question to compare their negligence? That's our scheme today, rather than
It went in regards to the analysis of the duty issue and the causation issue. We never challenged the issue that Dr. Edney said the magic words that Dr. Gehring was negligent. That was never part of the court's ruling, nor any position we've taken in front of the court.
Okay, the questioning has been why Dr. Kendall's negligence cut off the negligence of your client, and I'm asking why. I mean, isn't that the whole purpose of comparative negligence? When you have a bunch of people that are all negligent, you give it to the jury and you say who's most negligent, who's least negligent, and why didn't that system work here?
The timing of the interventions by the different doctors, the information known was that the judge, hearing the evidence, concluded that Dr. Edney's testimony was that this patient had suffered no harm and was in a position for over 1.5 years to have the diagnosis made without suffering any harm, in which the physician that was doing the well woman exams knew all of the same information plus additional information than Dr. Gehring, and that broke the causal chain of between the two. And that was the ruling. And I think it was an appropriate ruling.
From the trial court?
Yes.
I'm reading here, there is no legal duty, is what I'm hearing him say.
That was his statement, but...
And Dr. Edney said there was a duty. And that's all that's necessary to get over the directed verdict or the judgment as a matter of law, isn't it?
Well, yes and no. You can also look at the outcome of the case. Now, I know there was questions about whether this resulted in prejudice to the plaintiff tonight. And he said, well, it's obvious that the jury blamed and everybody blamed Dr. Gehring for this. If you look at the trial transcripts and then the briefs, the plaintiff brought up one piece of evidence, which was the one question to Dr. Smith, in which he said it was not the duty of the radiologist to do what you were asking him to do. At no time did anyone argue that Dr. Gehring was to blame for this. It was not in arguments, it was not instructed to them, it was not presented through any witness that Dr. Gehring was at fault, and so I don't want the court to be under the impression that the verdict was somehow impaired or because there was some allegation that Dr. Gehring was at fault or evidence that she was at fault. That never happened after Dr. Gehring was out of the case.
The trial court said your client had no legal duty to Ms. Russell. That was erroneous, based on Dr. Edney's testimony. Dr. Edney, who was the standard of care expert, said there was a duty.
Duty is a legal question and not a question for an expert witness, would be my response.
Thank you, counsel.
Thank you, Your Honor.
Chief Justice, members of the court, I'm Mark Maloney on behalf of Dr. Victoria Kendall this evening. And let me get right to it. When Dr. Kendall saw Stacy Russell in February 2009, she did obtain information that was different than what Dr. May had or Dr. Gehring had. The only source of information my client had was the verbal communication from Stacy Russell to her in that well woman exam, February 2009. What was relayed by Stacy Russell to Dr. Kendall was that she had a benign mass in her right breast. That is significant because as we work through why Dr. Kendall was found not to be at fault a significant piece of evidence that the jury was presented with was the treatise, which was which was Trial Exhibit 36, and it's in the Record on Appeal at Volume 26, pages 1 through 12. And there was a lot of talk about treatises and algorithms and decision trees, and when you find the word benign in that algorithm from Exhibit 36 from the trial court, it says you don't do anything. That is why the verdict against Dr. Kendall should stand. The jury heard from Dr. Edney, he heard from Stacey Russell. The jury saw a very capable counsel for the plaintiff appellant cross-examine Dr. Kendall, and they concluded after 9 days of evidence and testimony that Dr. Kendall did not cause a delay in the diagnosis in this case. There is nothing about the jury trial that the plaintiff appellant has raised in this appeal process that warrants setting aside that verdict and sending Dr. Kendall back for another trial. The issues surrounding jury instructions that were originally raised by the plaintiff have all been abandoned. This case is all about the dismissal of Dr. Gehring at the close of the plaintiff's case and as a judgment as a matter of law. I'm here to defend the verdict that was rendered exonerating my client, and it's my position that she should not be retried. There is no evidence on appeal of error. There's no proof of error. In fact, the plaintiff appellant doesn't even argue or assert any error as it relates to the trial against Dr. Kendall. It's all about Dr. Gehring. Dr. Kendall is in a different place in time. Dr. Kendall has different information. Dr. Kendall ultimately is exonerated and should not be retried.
Counsel?
Yes, sir.
There was expert testimony from the plaintiff's expert that was saying there was a duty owed and there was a breach of that duty, or there was a deviation of the standard of care for all the defendants. Is that correct?
I believe Dr. Edney said those words. Yes, sir.
And how does that then square with your position? I think you were referring to earlier the Lang 2008 current medical diagnosis and treatment. Is that correct?
Well, the Lang article is what the plaintiff likes to talk about.
You're referring to a different learned treatise.
Yes, sir. I'm referring to I keep saying plaintiff. Trial Exhibit 36, which is an ACOG, American College of Obstetrics and Gynecology article. It's entitled Benign Breast Disease, which is very supportive of Dr. Kendall's clinical judgment and thought process when she saw Stacey Russell in her office February 2009.
All right, thank you. Do you have any further questions? Thank you, counsel.
Thank you.
May it please the court. I'm Lisa McPherson, and I represent Dr. Lisa May, the radiologist in this case. You've spent a lot of time with questions and discussion about Dr. Gehring. I want to focus today, much like Mark Maloney did, on why this verdict in favor of Dr. May after 2 weeks of evidence should stand. Mr. Schultz was asked by one of you, what basis, I think it was you, Justice Breyer, what basis other than just saying this should be retried against all defendants do you have? And he answered fairness. And I think that's a good place to start, but for the other reason. I think that fundamental fairness says that Dr. May went through a trial for 2 weeks. She is separate and apart from any of the issues with the clinicians. There's no evidence in the record on appeal that she did anything inappropriate, wrong, negligent, below the standard of care. The record is completely void of any of that information. And she got a favorable verdict from the jury. There is no reason whatsoever to not allow that verdict to stand. She was given a fair trial, as was Stacey Russell against her. and Dr. May won, and that should stand. You know, the one little piece of information or one area that Mr. Schultz has talked to you all about, saying that it makes a difference for Dr. May, is this statement from Dr. Smith. And Dr. Smith is quoted many times in these briefs, and I'm sure you have read it and are tired of it. But it's important in that Mr. Schultz had sort of a twisted interpretation of what was actually said, and said that Dr. Smith blamed Dr. Gehring and used her name particularly. That's not at all what happened. The question was very specific as to what duty the radiologist had and whether the duty was the radiologist to send the results out to the patient. And to give the site, so you have it, volume 8, page 64, and volume 8, page 67, Dr. Smith was talking about, no, the radiologist just needs to communicate to the primary care doctor, to the referring doctor of who sent the patient for the mammogram. It had no words about Dr. Gehring, no blame whatsoever. It had no effect on this favorable verdict for Dr. May.
How did you get to a jury if there was no evidence against your client?
I figured you would ask that, and I was very careful when I said there's no evidence in the record on appeal, and that is that there is not one iota of criticism on Dr. May in the appeal. At trial, there was an expert by the plaintiff who presented some evidence in the court, and so there was that fact to go to the jury. But even with that, and there's a lot of other reasons, no, but the plaintiff did not put that information into the record on appeal. So for your consideration, clearly, the only evidence that we have in this record on appeal before you all today is that Dr. May met the standard of care, and that should stand. The other thing I wanted to visit with you all very quickly about is that I'm not even sure that the plaintiff has appropriately put a return to trial for Dr. May and frankly Dr. Kendall appropriately in front of you all. Supreme Court Rule 8.03 A4C states that the court will not consider issues not presented or fairly included in the petition. And if you look specifically at the issues presented to you all on the first page in the plaintiff's petition for review, there is not one statement in there about Dr. May or Dr. Kendall. It's all about the judgment as a matter of law for Dr. Gehring. So in that regard, although Mr. Schultz has put in here, I think the trial should go back to all defendants, it's not within the issues of appeal. The court, as the court is well aware, you also have the right to grant, if you choose to grant a retrial of this matter, you have the option under the Kearns versus GAC case, and that's cited in our brief, that you have the right to send this case back for any or all issues or any or all parties. And I would suggest that this is one of those situations. We have a favorable verdict on behalf of Dr. May, and that should stand. It is separate and apart and not linked at all to anything the clinicians did in this case. Dr. May read a mammogram, and according to the record on appeal, it was done appropriately. And 2 years later, Stacey Russell developed cancer. There's nothing
Is that basically the position here, is that Ms. Russell goes in for an exam in August of 2008, and in between the time of discovery of the cancer in August of 2010, she has numerous examinations regarding the initial finding of the lump by Dr. Gehring, that there's no failure to diagnose, there's no failure at any point along the way, but this just developed over the summer of 2010.
Essentially, there weren't numerous examinations by Dr. Gehring. Dr. Gehring didn't.
No, I understand that, but just numerous examinations that Ms. Russell had by the three defendants.
Well, after the mammogram and ultrasound was done by Dr. May in August of 2008, she had 2 examinations by Dr. Kendall, her OBGYN, and then felt a lump in the summer of 2010, and went and had it mammogrammed. And Dr. McGuire, who was the treating radiologist, and this is in the record on appeal, found a new finding of cancer. And it was the testimony in the record was that it was at a different location than where the issue had been before. So it was a new cancer was the position.
And that was part of your position at trial, was this was a
That's correct.
new cancer.
That's correct.
Counsel, I think you're out of time. Would you like 30 seconds to wrap up, or do you think you've made your points?
I would only like to wrap up very quickly, Your Honor, and say that I think that it would be a very bad precedent to just automatically send everybody back for a retrial just because comparative fault is at issue. I don't believe the law supports that, and it would make it very difficult for any judge, any efficiency, any lawyer to ever want a judgment as a matter of law granted to a co-defendant or another party in the case for fear that that was the precedent that they would have to go back for a retrial. We have a verdict, and I believe it should stand. Thank you.
Thank you, counsel. You're reserved 5 minutes for rebuttal.
Sometimes I think the defense lawyers are looking at the different case than I'm looking at. They tell you just a few minutes ago that we've never mentioned the idea of having all of the trials. This court may not have jurisdiction. The very first paragraph in the petition for review asks you to review the decision and the decision of the Court of Appeals denying a new trial against all defendants. Now, I think you could have jurisdiction anyway if you so choose, but you can't say that we didn't ask for it. They say that...
Well, let's stop there for a second. What ruling of the Court of Appeals on the issues that you brought up are we supposed to review that would require a reversal against the two doctors who went all the way to a jury verdict and got a successful verdict?
Well, if you go back to the original brief, and I don't have it right here, I've got it right over there. If you go back to that original brief, we raised the issue of the treatises and how they applied to the other doctors and the failure of the instructions there with regard to the learned treatises and how they could be interpreted, the requested instruction. So I think you can consider that. And certainly we talked about this whole concept of comparative negligence, as Justice Johnson talks about. The only way that Stacey Russell gets a fair trial is if she is entitled to have a jury compare the negligence. Let me give you another practical example, and I can't remember, someone asked, and I apologize that I can't recall. You know, Dr. Edney, here's another practical problem. Dr. Edney testified that both Dr. Kendall and Dr. Gehring were negligent, and largely along the same lines. So if you again send Stacey back to a trial involving only Dr. Gehring, and my only expert on that issue is Dr. Edney, Dr. Edney will come, and what is he going to say? On cross-examination, they're going to say, well, didn't you blame Dr. Kendall, and she's not here, or whatever they're going to say. And can it be successfully limited? No, as a practical matter, it probably can't. That becomes a real practical problem in these kind of deals. I don't...
Assume with me that there's no error in the trial of the other two doctors who went to verdict. Are you saying that those judgments get reversed if the judge was wrong on one of the other co-defendants? And if that's your position, what case law do you have to support that?
I don't have any case law on the tip of my tongue, I can tell you that.
Is there any in your brief? Because I didn't see it.
No.
This is a puzzle to me that somehow we come up on petition for review, and I can't find any place where you've said that the Court of Appeals made a mistake as to the other two defendants. Your argument seems to me to be focused entirely on Dr. Gehring, and if we agree with you, that's fine, but those guys still got a fair trial.
Well, I hear what you're saying, I just don't buy the premise that at the beginning, Dr. Gehring is the key. It's not my client's fault that Judge Vining goes off and lets Dr. Gehring out in the face of evidence that clearly puts her there. I didn't hear the defendant saying, hey, Judge, wait a minute, maybe this isn't such a good idea because I really think you're wrong on this point. They're not doing anything to protect the integrity of this whole process. I'm not entirely blaming them for that. I don't expect them to argue my case for me. But certainly there's that aspect of it. And then you still come down to fundamental fairness. They say, well, it's not fair. And I'm going, where is it fair to Stacey Russell? She didn't do anything wrong either. We put on a lot of evidence. This is a 2-week trial. These are not cheap things. And what did we do wrong? And so is she the only one that has to pay for the error of the judge? Unfortunately, I don't think that's true. I think everybody has to pay for it in a metaphorical sense. Let me just address, and I try to answer it. I hear Dr. Gehring's counsel say, well, this whole deal about fatty lobule and firm, palpable lump really never came up until after the fact. And I'm going, where do you get that? Dr. Edney, it's in the brief. It's in the supplemental brief. Dr. Edney testified in front of this jury while Dr. Gehring was still a defendant. If what you feel is inconsistent with what they see on an image, then you are compelled to biopsy it. In other words, if what you feel is firm, like this, and he's indicating, and they're saying what I see is a fatty lobule, that is an inconsistency. They have to be consistent. Where does he come up with the argument that says that was dreamed up somehow later on this appeal? The judge went off on I'm not even apologetic about arguing this. I mean, I don't know what he was thinking. I find a one-time visit to a doctor does not establish a requirement that the doctor call a patient and check up on their wellness. Who said that? Dr. Edney said, you biopsy it now, or set an appointment 3-4 months from now, come back and biopsy it. They've turned it in, and here Dr. Gehring's counsel also wrote in his brief, Dr. Gehring can't be held responsible for alleged failures of Kendall, where Dr. Gehring was simply tasked with recommending follow-up care. See, they've dumbed it down to it's just follow-up care, and since she went to see Dr. Kendall, that's follow-up care. They've ignored the part about, no, follow-up care includes evaluation and includes further testing as necessary, and it includes, if the lump is still there, absolutely a biopsy. And so these arguments they are puzzling, and I'll concede to you that this
The court will take this matter under advisement. Call the second case on this evening's docket. That is case number 112035, State of Kansas v. Marcus Gray.
Good evening, Your Honor. My name is Randall Hodgkinson. I'm appearing tonight on behalf of Marcus Gray. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Your Honor, at the outset, I wanted to make a note regarding the third issue in our brief that had to do with a claim that a defective complaint in this case resulted in a lack of jurisdiction on the part of the district court to impose the sentence that it did. As I've prepared for this argument, I recognize that my colleague and I neither had cited to you State v. Dunn, which was decided by this court July 15, 2016, which I think is adverse authority. I know this court knows of that case because you applied it last week in a case I lost. But in the context of my duty of candor to this court, I wanted to make sure I affirmatively noted that in this case. My intent today is primarily to argue to you about issue number 1 in this case, which has to do with applications of Kansas statutes which purport to reduce or prohibit racial profiling by police officers in the state of Kansas. So the facts that were discussed a little bit earlier have to do with my client who was driving between Wichita and Salina and being followed, and at some point being observed to fail to use his turn signal when making a turn. And, Your Honor, that's called a thing called a pretextual stop, because none of us believe, and in fact the officer fairly candidly noted, he was not really out there enforcing traffic signal laws at 2 a.m. along the interstate in Harvey County, but he was using this as a tool to have cause to stop and hopefully maybe develop some probable cause or reasonable suspicion. It's called a pretextual stop, and although I don't like it, it's been approved by the United States Supreme Court and adopted by this court, that a pretextual stop is a legal stop under the Fourth Amendment.
Which cuts you off on traditional Fourth Amendment analysis, right?
That's right.
We all agree on that. And that's what the judge was referencing. I think the district judge was referencing at the end of the suppression hearing. I've heard all I need to know. There was a turn signal violation. End of story. You're done.
That was the reason he stopped him, because of the turn signal.
Which ends a motion to suppress on a purely Fourth Amendment ground. So I want to try to get a fix on what it is exactly your basis is otherwise.
The basis
is this purely statutory? I mean, in other words, the intersection of the statutes having to do with racial profiling or race-based policing and the statute that says you can move to suppress on an unlawful search that does not specify it must be an unconstitutional search. Is that the essence of what you're saying? It's purely statutory?
Yes, Your Honor.
Okay.
The claim we're making in this case is purely statutory under KSA 22-4609 and related statutes. Statutes passed by the Kansas legislature in 2005 and amended in 2011, which prohibit racial and bias-based policing practices.
And to approach that from another angle, despite the fact that you cite Batson, you are not making an equal protection argument.
That I cited.
Batson.
That's right, Your Honor. And we put forward Batson as a proposed test because there's a lot of similarities between the harms that are being dealt with in Batson and the harms that we think the Kansas legislature is trying to address in these statutes.
And equal protection is the basis for challenging profiling, racial profiling.
We're not making an equal protection claim here, Your Honor.
Well, I understand that, but the bad thing is addressed through equal protection on both avenues. So if you're not making the equal protection argument, how do we use equal protection jurisprudence for the statutory claim you're making?
Sure. It's because what you said, because I think the evils that are being addressed in the equal protection analysis in Batson are the same evils that are being addressed in the Kansas statute prohibiting racial profiling. The idea that, and in Batson, the court, and by the way, I think it's interesting, the Court of Appeals even in this case cited Batson for the proposition that you can't exclude jurors because of race. And in fact, that's not true. That's not the actual holding of Batson. That was already the law of the United States. Batson just instituted a procedure recognizing,
it's remedial.
recognizing that the procedures that were already in place to prohibit that evil weren't working. And so it put an additional burden on the prosecutor and entered into judicial scrutiny to a place where we'd never had judicial scrutiny, the exercise of peremptory challenges. So it was a procedure used to address those evils. Why are we suggesting that in this case? Because we had to suggest some process by which we could give teeth to this statute.
But I think you're giving up too much in that regard, because on a motion to suppress, immediately the burden is on the state.
Yeah.
But if you go through Batson, the defendant on the first step has the burden. State has to give a race-neutral reason, and then the burden goes back to the defendant. If you're in a suppression, the defendant never has the burden. So why are you wanting to put more burden on the defendant? Or you understand what I'm saying?
Oh, yeah, I understand what you're saying. That normally I would stand out of a motion to suppress and say, I don't have to prove anything.
Yeah.
I don't have to do anything here.
I think we've had that conversation.
Although I think even at a Fourth Amendment motion to suppress, I still have some burden of production to show, for example, that there was a search
Right.
and maybe that there wasn't a warrant, or if there was. So even as a defendant, I may have some burden of production, sort of like that. And I guess to be honest with you, Your Honor, as we reviewed this case and worked on this case, we thought the statute itself doesn't really give a test. And that's the problem. And so as we think about what would be a proper test, we thought Batson seems to address the same kind of problems. Maybe we should use the same kind of solution.
But your problem's even further than that. The statute does give a remedy, but it's a civil remedy.
It gives a remedy, but it doesn't give a test or a process for deciding whether there's a violation of the statute.
I'm suggesting, when I talk to you about purely statutory, I'm suggesting that that the statutes having to do with racial profiling and race-based policing are really not the vehicle. The vehicle is the statute that says you can file a motion to suppress. They simply supply the content of why it was unlawful, which takes you away from the remedy that's provided. You have that remedy as well, is
Sure.
what I'm trying to get to.
That's right. I have civil remedies even in a Fourth Amendment case.
Right.
And so the fact that there are civil remedies doesn't mean that the search is lawful or that 22-3216 doesn't apply.
Walk through me here how this works, because I'm having trouble with the procedure and how the statute would kick in press or in a criminal case. Would it be that it would kick in if your client happens to be African American or minority? Is that the first indication where then the state would have some sort of evidentiary hurdle to overcome that this was not a profiling kind of scenario? Yeah. Which is kind of what they're arguing here. The officer didn't even recognize that your client was African American until well into the kind of following the driver around.
But before he seized my client.
Right.
He didn't seize my client until after he knew my client was black.
So how would it kick in? I mean, would it be every case in which there is a minority that has been arrested as a result of a traffic stop that this would be a question?
I think, yeah. I mean, the statute is designed to address an evil called racial profiling with findings, legislative sort of pronouncements about the prevalence of it. And so if we're gonna deal with that problem, like Batson dealt with the problem of striking jurors because of race, then we have to have some process or procedure that will meaningfully do that.
Can't we agree, though, that the defendant in filing a motion to suppress ought to at least say in the motion because of racial profiling or something like that, as opposed to what this defendant did, which is file a motion that just said, well, this search was unlawful, because the state had no idea, wouldn't you agree, that there was a racial profiling question until they got into the middle of the hearing and it started being argued by counsel. And that doesn't seem fair.
So there are two or three responses to that, Your Honor. So one is, yeah, you correctly recited that there was a fairly ambiguous motion filed, but at the suppression hearing, the defense attorney was very clear at the end that he was also asking for findings related to KSA 22-4609 and related statutes. And Your Honor, the state didn't object at that point, and the judge made findings then. If the state didn't like that procedure, this court has made it pretty clear to me in other cases that if I don't like the procedure that the trial court does, the proper procedure is for me to object to it at the trial court. And the state didn't object to it at the trial court. And the judge made the findings. The state had objected to it, and the trial court said, I don't agree with you. The state could have cross-appealed. And the second answer is the state made this claim to the Court of Appeals, Your Honor, and the Court of Appeals found that this issue was properly preserved, and the state didn't cross-petition on that either. So to the extent that there's any kind of concern about preservation, I think that's under the bridge as far as this case.
What about the other concern that the district court made a specific finding that the officer was credible when he denied any ill motive in pursuing this case, and we can't we can't do anything about a credibility finding when it gets up here, and it seems to me that's a pretty hard thing for you to get over.
Well, you're right, and that's why we have suggested and are arguing that the procedure used and adopted by the Court of Appeals is insufficient to meaningfully give any sort of teeth to this statute. That if the test is was there a pretextual stop? Well, if there wasn't if there wasn't an actual legal pretext, then it was a Fourth Amendment violation, we'd be out. And if the test is, was there a legal pretext, and did the officer say he didn't do it because of racial animus or something like that, we're done.
And was believed by the district court.
Yeah.
That's the key. I mean, we have all conflict in testimony
But that's
all the
just
time.
that's just like where we were before Batson with regard to jury strikes. That it wasn't legal to strike people because of their race before Batson, and prosecutors would say either I didn't do it because of that, or it's not even something you can inquire into. And that's why if you uphold the Court of Appeals in this, I'm not even really sure what the statute, how it has any sort of meaningful application in the state.
What kind of evidence would it take to show a racial profiling, absent that the officer would say, yeah, I took his minority status into account on the stop, absent that kind of testimony? And I think in the Batson line, I think there were statements made. I exercised my peremptory because this person was African American. And I don't think you'd have that in this kind of scenario. So to take evidence that's outside of the case, like in 50% of the cases and the stops that you've made over the last year, a certain percentage was this or that, would it be that? Or
yeah, I mean,
how would you do this?
Well, and that's part of our problem when we came into this case, because there isn't sort of a process for sort of figuring that out. I suppose an alternative would be every time the police officers, law enforcement, engage in some policing action with a client who is in a protected class or something like that, that it somehow opens up this issue, because if it's just based on what this officer said and his credibility, then I must be able to test his credibility, right?
Right.
And does that mean, therefore, I get, for example, all that officer's arrests, some sort of discovery about all that officer's arrests for some period of time, so that I can see how often did this particular officer stop people on I-135 between Salina and Wichita, and of those, how many of those were persons of color, and how many of those were not? Is that the... Your Honor, you could say, I mean, I don't have, that might be a test. That seems like a burdensome test.
It does, but I don't know. I'm just wondering what kind of, absent some sort of affirmative statement or admission that was the basis, I don't know what else you would.
I don't know what else there could be, and that's the reason we're here saying there should be a better process than that, like the one in Batson.
Help me understand how we apply the statute then. When we get to that point where we're doing that, we have KSA 22-4609. The first part of that says that it's unlawful to use racial or bias-based policing to determine the existence of probable cause to take into custody or to arrest an individual. Here, the basis for the detention was a traffic violation. So how do we get past that to get to racial profiling?
But I think the other parts of that statute make it clear that sort of any initiation of a law enforcement action is also covered within those statutes.
B is constituting a reasonable and articulable suspicion that an offense has been or is being committed so as to justify a detention of an individual or the investigatory stop of a vehicle. But we didn't have an investigatory stop. We had a traffic stop.
But it's a detention.
But it was a detention because of a traffic stop. Again, why doesn't the traffic stop...
But if it was a traffic stop based on race, I think it falls under these statutes. Certainly, I think it was the intent of these statutes to reduce or prevent pretextual stops based on race. So every time you have a pretextual stop, you have a traffic violation. And so if that takes us outside of the realm of this statute, then again, you really have gutted the statute.
I understand if we were looking at an investigatory stop, or even if the allegation here was once you move past the traffic stop, what was the probable cause to do an extended detention and to investigate the possibility of drugs or something else. But how do we get past the ability of police to enforce traffic or other basic laws simply because the driver is some sort of a minority classification? I guess maybe this goes back into the questions that Justice Rosen was asking.
I mean, the race-based policing means the unreasonable use of race by a law enforcement officer in deciding to initiate an enforcement action.
But that's where then we get back to the credibility determination of the judge that that is not what happened here. Are we back to, I mean.
Yeah,
seems like
I think that's right. I mean, that we're back to this place that if that's enough, that the officer says, I didn't do it because he was black, I don't know why we have the statute any longer. I mean, and it's sort of, seems very contrary to the purpose of the statute, which seems to be like we want to robustly stop this practice of race-based pretextual stop.
Counsel, go ahead.
Go ahead, Caleb.
You talk about the purpose of the statute, and that was my question. Regardless of the procedure that might be used, the ultimate remedy you seek is suppression, right? There's
Yes.
no other remedy that you're seeking.
And it's a criminal case, that's right.
Recently, we have some case law in which we've looked at other statutes that prohibit certain police behavior, particularly police acting outside their municipal jurisdiction. And we've looked at that and said suppression is not an appropriate remedy because that statute doesn't say suppression, just like here we don't have a statute that specifically says you can get suppression. Can you distinguish this statute from those earlier statutes that we've said, yes, this may in fact be unlawful under Kansas law, but suppression of the evidence is not a remedy?
Sure. The distinction is in Vrabel, the case I think that you're talking about, the court noted that the statutes that were involved there regarding the authority of the law enforcement officers in different jurisdictions didn't create an individual right with any particular defendant, that it had to do with the allocation of sort of powers between municipalities or between law enforcement agencies. And because that doesn't involve a particular individual, you said that suppression isn't warranted even if it's unlawfully done. But I think clearly here, by virtue in part of the nature of the claim, which is obviously affecting an individual.
Well, but why can't we look at the statute and say the legislature determined that the harm they were intending to prevent is remedied by the provision of a civil remedy, and that's where they intended this to stop. And otherwise, it's a regulatory scheme imposed on law enforcement, and it is clear, I agree with you, clearly they want to stop this practice. What's less clear to me is that the legislature thought that suppression of the evidence might be appropriate.
So I think the answer is, I would actually look at that language that you cited to make it clear, to finish my earlier point, that it's clear through this statute they do intend to provide an individual right on behalf of somebody. And
it's a civil right, at least
that's a civil right in that part of it. Right. But it doesn't say this is the only remedy. And they could have said that. They could have said this provides no remedy under 2232-16, but they didn't. And in fact, even for Fourth Amendment violations and things like that, there's a civil remedy. It's just that, and that doesn't mean that we don't get to make Fourth Amendment claims for suppression. So I think for both of those reasons, the Court of Appeals was right to find that a violation of this statute should result in suppression. And again, also an issue not cross-petitioned by the state, that finding by the Court of Appeals.
Why wouldn't you pursue a selective prosecution approach rather than a motion to suppress? It seems like that is a part of the law right now, and you're trying to invent something that it hasn't been there previously.
Sure. And in fact, in Wren, I mean, they make it clear, it seems, that there would be such a thing. But the impossibility of proof is what makes it so difficult to make that equal protection claim as a selective prosecution kind of issue. The ability to prove that is extraordinarily difficult. And so it puts it, that's why I don't think that as a sort of process for this kind of claim would be very effective either.
But you don't seem to care that it would be unfair, the fairness to the state of trying to disprove something that's very hard. I mean, you're asking them to prove a negative.
Yeah, I'm asking them to prove that this was not done
beyond
with
just
racial...
the credibility of the officer. I mean, that's the thing here. We've got a credibility determination. But what else could the state do?
I think the way it ends up, if you adopt our approach, very much like Batson, is you're going to have to show something additional, something more than just a pretextual stop. Just more than the traffic violation that was the pretextual stop. And if you can't do that, and the person is in a protected class, then it's a violation of the statute.
So is it enough that the officer testified that this was a male who was not on the registration of the car, and that in his experience, those who were trafficking drugs or other things often used that so that the car couldn't be traced back to the driver?
Obviously, we would argue no, and I would cite to even the district court. Now, I think if you adopt this approach, maybe the end result is, and you say that's the question that we have, here's what you would have to show, perhaps it would be remanded for findings on that. But the district court in this case said, when he was making his findings, that I find none of those other things really add up to anything. He based his decision entirely on the failure to stop.
Excuse me, we have time for one more question. I hope it's a really good one.
No pressure.
No pressure.
Well, that's the Fourth Amendment deal, though. That's going back to the Fourth Amendment, which is not where we are, right?
So
that's where we started.
So sort of quantifying or evaluating that additional evidence that Justice Luker talked about, I suppose really hasn't been done maybe. But if this court announces a test and says, here's what you have to show in these situations, I'm just saying that there's evidence in this record that the district court did not find that evidence particularly probative.
So at a minimum, you're entitled to go back and have them make the findings under the correct legal standard.
Yeah.
Okay. Thank you, counsel. We'll see you on rebuttal. I know.
Your Honors, I think Justice Breyer noted that the district court did say, that's all I need in this case. And if you look at the transcript, there is a generic motion to suppress, which is a common practice these days by defense counsel. And at the very first of the hearing, I addressed this with the district court judge and asked for a statement to limit the issues by the defense. And the court granted my motion for that. And then the argument was limited, is there probable cause for the detention in this case and later arrest? Those were the issues that the defense counsel chose to limit the case to, or that motion to, on the day of the hearing. And then we get to the point at the very end of the hearing, in his best attempt at his Perry Mason moment, to throw in, but there's a statute, Your Honor, and I want you to make findings. So to allow this to go is a condoning or allowing this kind of behavior, when really we're trying to sit here and seek justice. This isn't the old days where we got the gotcha courts. This is where we actually try to find the truth and get to the issues.
But these are the days when the state loses its preservation argument. You then, and they seek a review of the case, you come in on a cross petition for review and say the Court of Appeals erred when it found that the issue was preserved, because it wasn't because of this district court order at the beginning of the hearing. We don't have that in this case, so how can we get too animated about it?
Because you have to consider, do you have jurisdiction to hear this issue in the first place? Was that jurisdiction ever created? Was a burden ever shifted to the state? And that never happened.
Are we in jurisdiction land, or are we in preservation land?
How is it different, in my opinion?
Okay, I think we've said repeatedly that they are different.
Sorry, I apologize.
No, that's okay. It's hard sometimes to not talk over one another. I think we've said repeatedly that jurisdiction and preservation are different. Jurisdiction is not a matter of discretion, whereas preservation is more of a prudential consideration than a jurisdictional concept. Haven't we said that quite often?
I believe so, but they do intermingle, if you would agree with me. And when one is lacking, it often affects the other one. In this case, it was whether this was even brought up appropriately. But to get to the point of this racial profiling statute, the statute creates a prohibition against the unreasonable use of race in deciding to initiate a law enforcement action. Now, going back just a little bit to my last argument, the burden does shift to the state. And in this case, the burden was on me to present evidence to the court, finding that there was a reasonable suspicion for the traffic stop. At the end of the hearing, when we present the statute, again, if it was brought up in the motion, the state would have presented evidence focused on that issue. And then we would have a non-issue here in the first place.
Do you think, counsel, that defendants have suppression of the evidence as a remedy? And that's what it sounds like you're saying. You're complaining about kind of the surprise gotcha moment, and you're saying we would have just presented evidence to demonstrate that we didn't violate the statute. Is that the position that you're taking?
Well, modified a little bit, because in this case, I happen to have presented enough evidence, I believe, for the district court to make the appropriate findings in this case. I believe that's why Judge Malone decided it was an appropriate issue to consider whether or not the issue was preserved in the first place. Now, I did talk about in my...
Your position is we didn't violate the statute, as opposed to, regardless of whether we violated the statute, there's no remedy available.
I am taking both positions. Not only did we not violate the statute, but an argument if we did violate the statute doesn't create the remedy of suppression that's being sought by the defense. And I want to make this very clear, because if we're basing it on the statutory violation of 224609, the racial profiling statute, as Judge Malone said, that gets encompassed into 223216, which is a suppression of evidence under unlawful search and seizure. There's a very clear difference between an unlawful seizure and an unlawful action prior to the seizure. And what is being argued is that the officer conducted unlawful acts prior to the seizure itself, but not an unlawful seizure in this case. And where it comes down to, and this is where the Fourth Amendment pops in, is I think we get some guidance. Because under Wren, the courts have struggled with this issue. How do we take the unlawful acts prior to the seizure and find if there's any violation, as opposed to the actual seizure being unlawful as for being seized to a traffic violation? And what they said in Wren is we're going to allow pretext stops because there is a lawful reason for the actual seizure itself. So to say that the other statute, the initiation of the seizure, or the beginning following of a person based on race, it does create an impossible burden to say what were the motives of this officer in this act.
Well, counsel, you would agree with me that the state is permitted to impose greater protection or greater restrictions on law enforcement for the purposes of providing greater protections than are provided by the federal Constitution to the citizens of Kansas.
Absolutely.
So the legislature, for example, could decide to pass a statute that says no pretextual stops in Kansas. We understand that they're permitted under the Constitution, but we say they aren't permitted in Kansas. So why isn't that what's really happened here?
In effect, they did say no pretextual stops based on race.
And so why wouldn't suppression be an appropriate remedy?
Because then you start adding your own words into that statute.
Well, we have a statute that says you can get suppression for an unlawful stops, an unlawful seizure. Why isn't that enough right there?
Because there's nothing connecting the unlawful initiation of an action that automatically creates the seizure itself to be unlawful. You have to jump there and make the conclusion without any intervening statute or any intervening authority.
So your position is that law enforcement can conduct a lawful stop that is initiated unlawfully?
It can, and even under the Fourth Amendment it can.
Well, the Fourth Amendment doesn't have anything to do with this, does it? We're talking about statute.
But here's where it comes together. You can on the Fourth Amendment, but the 14th Amendment then comes in on equal protection. Is the statute really intended by the legislature to be a substitute for an equal protection argument? There's nothing to indicate that that's what this is here for. The statute, I believe, is absolutely addressing the issues created under cases like State v. Wren, where there is no remedy, but the remedy the state chose itself in its own words is a civil remedy through the Attorney General's office for investigation.
Here it shows that remedy, but that other remedy exists, and I think that's what my colleague is trying to get you to focus on.
And the remedy you're talking about is under the search and seizure statute, or the suppression of...
Under the suppression statute,
And again, I think we're making that leap just because the initial action might have been racially biased.
Well, let's look at the statute that you want to focus on. Let's look at 22-409. And it says it is unlawful to use racial or other bias-based policing in, and then it lists what it's unlawful to use it for. And the things it lists are arriving at the reason to stop someone. So I'm not really sure that we can make that distinction you're trying to get us to draw between what motivates behavior that precedes the stop and the stop itself. Because it looks like this statute is deliberately written very broadly. Help me with that.
And the point is, it's going to be hard-pressed to find a case that comes before your honors where race is the sole issue and the sole motivating factor to be
What I'm
presented
suggesting
in
is
the
it doesn't
statute.
have to be the sole motivating factor. You see what I'm saying? That's what I think you have the trouble here, because it says you can't use it. That doesn't say you can't use it solely, or it can't be the sole basis. It says you can't use it, period.
Well, Your Honor, I would hate to be that prosecutor who has an officer on the stand and said, I pulled this gentleman over or this person over based on their race, along with these other factors. And if I'm that prosecutor before you arguing it, it's time for me to quit and retire. Because that's not what justice is, and that's not what this case presents, and that's not what the statute is seeking to prevent.
Well, what happens if the basis, and let's just look at the basis here. He observes a vehicle in the middle of the night or early morning hours that happens to be, I think, registered. The license plate indicates it's from Saline County. He must observe that the operator of the vehicle is male because he discovers that the vehicle is registered to a female. And those two factors generate suspicion in his mind based on his past experience or based on his experience. Are reasons like that, are they rational? Are those reasons sufficient enough to raise suspicion to follow the vehicle? And then another reason he gives is that then he pulls into a gas station, as I understand it, with a vehicle that has the gas where you I don't know what you could, where you put the gas into the car is on the passenger side of the car, and he thinks it's suspicious because he pulls in on the correct side of where the gas pump is, and he's wrong in his suspicion because he thinks it's on the driver's side. I mean, are these reasons enough to don't the reasons have to have some rational or credible basis before you can then not throw into the mix? Well, are these just kind of justifications that are suspect because I'm really following him part of his the status of the driver? If that makes sense. I mean, it's almost like we get into when the defendant got up and talks about Batson. We hear all kinds of reasons for race-neutral reasons. Some have some basis to them, some don't. It's almost like that. Kind of wondering, what about the credibility of the basis in the first place?
So what Your Honor is suggesting is that we create a presumption that every stop must be unlawful until proven otherwise.
No, I'm not saying that. It has to be justified by some understanding that's. I mean, is that enough? I'm following this car because it's late at night and it's an out-of-county plate, and the driver happens to be a different gender than the person that's registered to. That's enough?
I do believe it is, Your Honor, because you have an officer who has his training experience, is every day out there on the street enforcing these laws, and has his own vision of what's going on. It is not us in our offices behind computers working the paperwork every day who don't know the common everyday dealings in these situations. And I think that's why we have to have these credibility determinations at the district court level, which was the focus here, on why there was no race-based reason for the stop. It was clear from the evidence to the district court judge and based on the credibility of that officer compared to the testimony of the defendant that this was not the case. Going back to the unlawfulness, and I think I have a nice analogy here. So if it's the initiation, if it's the unlawful act of the officer, when he initiates the stop, creates the actual seizure unlawful itself, then the officer who's stopping a person for speeding, who violates the speeding law himself by not turning on his lights and sirens, which he is obligated to follow, and the statute says it's unlawful to speed, he is now in the unlawful initiation of that stop, trying to catch up to the person. Does that make the seizure of the person unlawful because they were speeding? It does not. So to say that this statute, the initiation part, creates an automatic unlawfulness of the seizure itself, it doesn't reach to the logical conclusion when you create all the scenarios out there.
And I wouldn't suggest that it might, but for that really broad language. That's the trouble. That's what we're struggling with.
And another trouble is, did you note in opposing counsel's brief the testimony before the Federal and State Affairs, Federal and State Affairs regarding in 2005? They talk about the well-documented discrimination against communities of color, talk that there's extensive use of racial profiling by police of Hispanic and black motorists, and then they talk about the three most often cited instances of this discriminatory occurrence were, number one, when vehicles failed to signal 100 feet from a turn. And we have an officer here that says, I noted during the time that I was trying to catch him doing something that he was black and that he used that particular statute. Why doesn't that raise the burden for you, given that we start with you can't seize someone without a warrant, and if you do, it's presumed unlawful unless you fit into an exception? You would agree with that?
Yes.
So you do, in fact, have a presumption that you have to overcome. Would you agree?
It depends how you rule on this case.
Okay.
Because the burden is only created if you find that the race-based statute does create a suppression issue, which I argue it does not. If you create that presumption today, which I don't believe it's been in the law before today, this is going to be your own creation that we'll now have to follow. But is it appropriate? I think the appropriate remedy is to allow these cases to still follow the Fourth Amendment jurisprudence and the 14th Amendment jurisprudence when we have issues of race in our cases. Because we've got the law, we know what the law is, and we try to mold ourselves to that, instead of relying on a very broad-based legislative directive with no indication of how this is to be enforced except for a civil remedy. Is this really the substitute for an equal protection claim? That is the claim that needed to be brought here if that was the issue, and it absolutely was not.
But how do we square that argument with the language of the suppression statute that talks about an unlawful? If it is unlawful, why can't it be suppressed, regardless of the source of the unlawfulness?
If the seizure itself is unlawful, under Kansas statute, the evidence shall be suppressed. That's the law.
So you would agree with that?
Black and white, yes.
Yes. And so if a seizure occurs because of racial profiling, that violates the statute?
I disagree with that point.
And why? Just because the remedy, it may not be the remedy provided for, but the statute says it's unlawful.
Because the seizure itself is not unlawful because there was a valid traffic infraction. Because once there's a valid traffic infraction, that seizure is lawful in itself.
Under the Fourth Amendment.
under the Fourth Amendment, and why not under Kansas law?
Well, what about equal protection? Would you agree with me that Wren said that racial profiling can't be used for a pretextual stop, that violates equal protection if you use the pretext to stop based on race?
Absolutely, this should have been an
Okay,
equal protection argument.
And if you violate the equal protection, doesn't that make it an unlawful stop? I mean, isn't that unlawful to violate the equal protection clause?
If you actually have the findings, it's in violation of the Equal Protection Clause, which says,
And if it does violate equal protection, why isn't that also unlawful under the language of the suppression statute?
because the suppression statute isn't written in a way to encompass equal protection. It just says this action of officers will be deemed unlawful, and there's a civil remedy for that.
But let me take you back to the language of the statute that I read to council. And it is that it's unlawful to use racial or other bias-based policing in determining the existence of probable cause. And here I think the argument is that by following this driver until he committed a traffic violation, he was using the racial or bias-based policing as he was determining probable cause, not in whether he assessed that probable cause existed, but in the action leading. To your point, it seems to address leading up to the seizure.
Let me be very clear.
Let me interrupt. That will be our last question.
The
So I hope you
fact-
have a great answer.
Procedure should be used in these cases. And the argument is that if, by argument, there had been any kind of race-based policing in the initiation of the stop, what is the ultimate conclusion under Kansas statute? And the Kansas statutes do not clearly identify a suppression requirement. They clearly identify a civil remedy under these racial and other bias-based policing statutes.
All right, thank you, counsel. And we have 3 minutes reserved for rebuttal.
Your Honor, I don't think I have anything in direct response to anything my colleague said, so I'll waive rebuttal, except as the court has questions.
Counsel, what is your view on why this statute is found in Chapter 22?
Why it's found in Chapter 22? I think it recognizes that, it's the chapter for criminal procedure, and I think it recognizes that these race-based, this racial profiling is taking place in the law enforcement procedures, leading to criminal convictions.
All right. Any further questions? I see none. Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this evening. Court will take this matter under advisement. Now for the word you've all been waiting for. That concludes our evening session docket. Court is now adjourned, and we look forward to seeing you outside in about 5 minutes. Thank you.
All right.